Your phone buzzes on the passenger seat. Blue and red lights fill your rearview mirror. You pull over, hands at 10 and 2, heart pounding a little faster than you'd like to admit. The officer walks up, asks for your license and registration, and then, almost casually, says something that changes everything. "Mind if I take a look at your phone?" In that exact moment, something happens inside most people's heads, a kind of quiet panic. Not because you've done anything wrong, but because your phone isn't just a phone anymore. It's your diary, your bank, your photo album, your private conversations with your spouse, your doctor, your kids. It's basically your entire life compressed into a 5-inch screen. And now a stranger with a badge is asking to look inside it. So what do you actually say? Do you have to hand it over? Can they take it from you if you say no? And here's the part almost nobody thinks about until it's too late. Even if they don't take your phone, can they still get your text messages another way without you ever knowing? That last question is the one that should really make you sit up straight, because the answer involves a legal loophole that most Americans have never heard of, one that the Supreme Court has only partially closed, and understanding it could be the difference between protecting your privacy and handing it over without realizing you had a choice. Let's start with the traffic stop scenario, because that's where most people first encounter this issue. The Fourth Amendment to the United States Constitution protects you against unreasonable searches and seizures. That phrase, unreasonable searches, is doing a lot of heavy lifting in American law, and for decades, courts struggled with how it applied to something the founders never could have imagined, a device that holds more personal information than a person's entire house used to hold. For a long time, the rules around searching things on your person during an arrest were pretty loose. If police arrested you, they could generally search items you were carrying, no warrant required, under something called search incident to arrest. The logic made sense for a wallet or a cigarette pack. Officers needed to check for weapons and prevent evidence from being destroyed. But then smartphones showed up, and suddenly that old rule started to look dangerously outdated. In 2014, the Supreme Court finally addressed this head-on in a case called Riley versus California. And what happened in that case is honestly kind of wild when you hear the details. David Riley was pulled over for driving with expired tags. During the stop, officers found guns in his car and arrested him. As part of that arrest, an officer looked through his smartphone and found photos and text messages that seemed to connect Riley to gang activity, which prosecutors later used to link him to a shooting. Riley's lawyers argued that searching his phone without a warrant violated his Fourth Amendment rights. The state argued it was no different than searching his pockets. The Supreme Court disagreed, unanimously. Chief Justice John Roberts, writing for the entire court, essentially said that comparing a smartphone search to searching someone's pockets is like riding on horseback to a flight to the moon. The court recognized that modern phones aren't just objects, they're portals into someone's entire private life, containing everything from location history to medical information to private messages spanning years. The ruling was clear. In most cases, police need a warrant to search the contents of your phone, even after a lawful arrest. That includes your text messages. Now, at this point, you might feel a wave of relief. Great, the Supreme Court has your back. But hold on, because this is exactly where things get more complicated, and where a lot of people get a false sense of security. Riley versus California covered searches during an arrest. But what about situations where you're not arrested? What about a routine traffic stop where no one's going to jail and an officer just asks to look at your phone? Here's the truth. If you are not under arrest and police want to search your phone, they generally need either a warrant or your voluntary consent. And this is the part where most people accidentally give away rights they didn't even know they had. Because when someone in a uniform standing at your car window asks, "Mind if I take a look at your phone?" most people say yes. not because they're guilty of anything, but because saying no feels confrontational. It feels like you're hiding something, even when you're not. Psychologists who study police encounters have pointed out that this instinct to comply, to avoid conflict with authority, is incredibly strong, even among people who know their rights. But here's what you need to understand. Consent has to be voluntary, and you are allowed to say no, politely, calmly, but clearly. Something as simple as, "I don't consent to a search of my phone," is a completely legal thing to say. It's not obstruction, it's not resisting, it's you exercising a constitutional right the same way you'd use your right to remain silent. Now, does saying no guarantee they walk away? No, an officer might still detain you, might still try to get a warrant if they believe there's probable cause, but without your consent and without a warrant, they generally cannot lawfully search the contents of your phone during a typical traffic stop. So that covers the phone sitting in your hand, but now let's talk about the part almost nobody thinks about, the loophole hiding in plain sight. What if police never touch your phone at all? This is where things get genuinely surprising and where we have to talk about a legal concept that sounds boring on the surface, but is actually one of the most consequential ideas in modern privacy law. It's called the Third-Party Doctrine. Here's the basic idea. For decades, courts operated under the principle that once you voluntarily share information with a third party, like a bank or a phone company, you lose a reasonable expectation of privacy in that information. That means the government could potentially get records about you from that third party without needing a warrant, because legally speaking, you already gave that information away. Now think about what that means for your phone. Every text message you send passes through your cell carrier's servers. Every call you make gets logged. Every time your phone connects to a cell tower, that carrier creates a record of roughly where you were. Under the old third-party doctrine logic, all of that could arguably be fair game without a warrant because you shared it with your phone company. This should be sending a chill down your spine because it means that even if you refuse to hand over your phone during a car stop, there might be an entirely separate path for law enforcement to access records about your communications and your location, just by going to your phone carrier instead of going to you. For years, this was a massive gray area, and law enforcement agencies used it. But then, in 2018, the Supreme Court stepped in again in a case that reshaped digital privacy law almost as much as Riley did. The case was Carpenter versus United States. Timothy Carpenter was suspected of involvement in a string of robberies, and to build his case, investigators obtained months of his cell phone location records from his wireless carriers without a warrant, relying on that old third-party doctrine. Those records let investigators track Carpenter's movements over 127 days, painting an almost minute-by-minute picture of everywhere he'd been. The Supreme Court ruled that this went too far. In a 5-4 decision, the court held that accessing this kind of detailed historical cell site location data does require a warrant, because unlike a bank record or a utility bill, your phone's location data creates an intimate, comprehensive record of your movements that reveals far more about your private life than the third-party doctrine was ever meant to expose. Chief Justice Roberts again wrote the majority opinion, and he specifically noted that this was a narrow ruling. It applied to historical cell site location data. It didn't necessarily throw out the third-party doctrine entirely for everything else. And that word narrow matters a lot because Carpenter didn't answer every question about text message content itself. Whether police need a warrant to obtain the actual content of your text messages directly from a carrier versus just location records is an area where the legal landscape gets more complicated and can depend heavily on federal statutes like the Stored Communications Act, as well as how courts in different jurisdictions have interpreted these issues since Carpenter came down. That's the uncomfortable truth here. Digital privacy law in America isn't one single simple rule. It's a patchwork built case by case, technology by technology, often lagging years behind the devices we actually use.
So let's bring this back down to something practical, something you can actually use the next time you're standing at that car window with your heart pounding. If police ask to search your phone during a stop, you have the right to say no. That refusal alone is not probable cause for anything. Stay calm, stay polite, but be clear. Something like, "Officer, I don't consent to a search of my phone," said respectfully is enough. If you are arrested, remember what Riley versus California established. In most circumstances, they still need a warrant to dig through your phone's contents, even though you're in custody. There are narrow exceptions, like genuine emergencies where officers believe there's an immediate risk to someone's safety, but those are meant to be exceptions, not the rule. And understand that even without your phone, records about your calls, texts, and location might exist with your carrier. And after Carpenter, at least historical location data generally require a warrant to access. But this is a rapidly evolving area of law, and protections can vary depending on the type of data involved, the jurisdiction, and ongoing court decisions. Here's what I want you to sit with for a second. 50 years ago, none of this would have been a conversation because there was no way for a single device to hold this much of a person's life. The Constitution was written in an era of paper letters and physical searches, and yet somehow, through cases like Riley and Carpenter, courts have had to stretch 18th century language to cover technology that didn't exist even 20 years ago. That's not a flaw in the system. That's the system working the way it's supposed to, adapting slowly, case by case, technology by technology, to protect a right that's always mattered, the right to be secure in your private life, even as the definition of private life keeps expanding into new digital territory. But here's the biggest insight, the one thing I want you to walk away with. Your rights on paper only matter if you know how to use them in the moment. Most people don't lose their privacy because the law failed them. They lose it because, standing on the side of the road with lights flashing behind them, they didn't know they were allowed to say no. So the next time you're asked, remember this: calm, respectful, clear. You can comply with lawful instructions, keep the interaction peaceful, and still protect what's yours, because those two things are not in conflict. Knowing your rights isn't about being difficult, it's about not giving away in a moment of nervousness something the Constitution promised to protect. If this raised more questions for you, especially about what happens if police already have a warrant, or how encryption and passcodes fit into all of this, I've got another video that breaks down exactly what happens when officers ask you to unlock your phone, and why the rules there are surprisingly different from what most people assume. Go check that one out next, because this story doesn't end here.